Numbers 31 and 32, People versus Taft Lewis, 16432 FH.
Well, this was adjourned from last week. So here we are.
Here we are. You have the opportunity to speak to Mr. Lewis.
Not really directly to Mr. Lewis. We did mention to Mr. Judge Conlon that I was thinking, based on the fact that he's been struggling financially, if the court would be willing to waive the waivable fees, that would leave him a $73 mandatory balance. We never really got that far. So,
okay. All right. I see there's a range on the bench warrant. He'll owe 73.
yes, that's correct.
What's the amount of the waivable?
He owes $2,045.80.
Damn!
Of that total, $73 is mandatory.
Okay.
And he's paid $125 so far.
Damn, buddy. You still got quite a bit of a balance left.
Mr. Attorney General, what do you have to say?
Well, I guess I'm not entirely clear on the basis of the violation. I don't have, I'm not sure I've received documents regarding that. With respect to the underlying child support case, Mr. Lewis currently owes $21,415.70.
Good Lord.
And he has a current obligation of $66 a month. That's 66. And his last payment was in August of 2022. Further, I also am not sure if Mr. Lewis has any representation in this matter or not.
No, I'll be representing myself.
He said that with some confidence. This should be good.
Oh, okay.
I have PD written down here, but.
I did try and see him this morning, Your Honor, but he said he's representing himself.
Yes, ma'am.
Oh, okay. So I'm sorry. I thought Mr. Gaddy was here on this. Sorry.
There's two issues,
Okay.
the collections issue and then the probation violation.
Okay. So as to the collection issue, I can waive the waivable amounts. And Mr. Petherbridge, if you submit an order for that, leave
Will do, Your Honor.
balance at 73, you said?
Yes, that's correct.
Okay. And Mr. Lewis.
Can I speak now, Your Honor?
Yep, just a minute.
No problem.
Okay. Mr. Lewis, pursuant to Court Rule 6005, you have the right to the assistance of an attorney. So I can read you this section here if you're interested in
No, ma'am.
representing yourself.
Yes, I am, ma'am.
You are interested in representing yourself.
Yes, I've been representing myself since 2010, ma'am.
And because of that, you're currently incarcerated and owe over $20,000 in child support. Good job, Bub.
Okay. Well, so then you've probably heard this a time or two, but we're supposed to read it to you every single time you come to court.
No problem.
Okay. So hold on just 1 second. Says here under subsection D, the court may, and this is in the initial waiver, so I'm assuming some other judge did this for you, but if not, here it goes. You are being advised that of the charge that you have in front of you, the violation of probation, for which you have a VOP that is pending, alleges that you violated condition number 3 about making a truthful report to your probation officer monthly, as that they required, and that you failed to report on 1/26/23, and that you on 1/27/23 a call was placed to you and contact was made. You said you were going to turn yourself in on the warrant. The potential penalty in this case is up to 5 years and or $5,000. And I will read this verbatim. Advising the defendant of the charge, the maximum possible prison sentence for the offense, any mandatory minimum required by law, and the risk involving self-representation. In addition to that, I will offer you the opportunity to consult with a lawyer that you can retain of your choosing Currently you're in custody, so I'd also appoint the public defender's office if you wanted assistance. And that's my understanding that you are not interested.
No assistance needed, Your Honor.
Okay. This is your choice. All right, so how are we proceeding with the violation of probation?
Your Honor, I don't respect the reason I'm here today, but I will not disrespect your court because of others' egregious actions towards me. This is our first time meeting, and I plan on it being our last. Before Mr. Breckenbridge left, I would have liked to address the whole panel. So that I had just a few questions for him to set precedent so that everyone's stance could be evident and clear and no misinterpretations. But I see Mr. Breckenbridge tucked tail and ran.
Well, we're making a recording and he's still here. He just was out of the camera view.
This dude is already starting off with some nonsense. Excuse me, sir. Nobody is running or ducking tail from you. You're in prison, okay? You're a criminal. Why would a prosecutor run from you?
Great. Mr. Breckenbridge, can you please state your full name and title for the record?
Scott.
Mr. Lewis, this is not your hearing.
I can't address the panel.
There's no panel.
You have the probation officer, you have the court fines and fee officer, and you have the assistant general.
And everyone put their appearances on the record. So we're going to move it along.
No problem. I can get right to it. That is fine.
All right.
The law is my protection and I shall find remedy in it. Before we begin this process, I would like to address the court. In addressing the court, I would like to fully read and completely express all information today without interruption. I have two questions for the court. First question is, are all laws commercial?
Why in the doohickey would all laws be commercial? What type of stupid ass question is that?
Second question.
Mr. Lewis.
Yes, ma'am.
We have a violation of probation in front of you. I understand that you have been arraigned on the violation of probation. And because you are decided that you want to act as your own counsel, I will hold you to the same standards as I would any other defense counsel in this same procedure and within this same case. So as to the violation of probation, you can accept responsibility by pleading guilty to the violation or no contest. You can set this matter for a hearing in which we go forward, but this is not your hearing to run. Do you understand?
Yes, ma'am. I just wanted to address the court and put on record some very variable value information. And by
asking me questions is not putting information that you have on the record.
Yes, ma'am. I won't ask any more questions. Can I finish my statement? I have no more questions.
My question for you is, how are we proceeding with the hearing today? Are we proceeding with an acceptance, or are we proceeding that we need to set this matter for hearing?
Ma'am, this is not even a hearing that we should be having. If I could finish my statement, you could see that unless the AG has certain information, this is totally in violation and I'm not able to express myself. Like I said, I have no more questions. I just would like to read the information I have, and then they can go which direction they want to after the information has been expressed, ma'am.
Okay, tell me if you feel like the petition for your violation of probation is wanton in some regard.
It is not wanted at all, Your Honor. I shouldn't be.
It's not wanton?
I shouldn't be.
So you believe that it's accurate?
No, I believe it's inaccurate. I believe me being on probation is inaccurate.
Okay. Quickly, Mr. Taft Lewis.
I can finish. Thank you. I am the de jure. I am not an imbecile in law. I do not surrender my inalienable rights for any civil liberties. I am a five-fifths realized being and not a three-fifths dressed got compromised imbecile in law.
What? Bro, what are you talking about, man? Bro, I'm out, man. That nigga's tripping.
I'm here today for the non-payment of what is commonly known as child support. For the record, there's no such thing as child support.
There is no such thing as child support? What the hell are you talking about, sir?
The real reason I'm here today is because you're trying to enforce a contract/agreement by forcing me or compelling me to be a surety for a
Mr. Lewis, are you telling me that you're a sovereign citizen and you do not believe that the
Ma'am,
orders of the court apply to you?
No, ma'am, I'm not sovereign at all. I'm just speaking, I'm just expressing why.
That's what you just said.
I said I'm a 5/5 realized being, ma'am.
Okay.
That's
So
not.
these are, I need you, if you can't answer my question, we're gonna adjourn this until you can get a hearing, and I'm gonna appoint standby counsel with a public defender.
I don't want
Thank you.
counsel, ma'am. I just want to finish.
I understand that. So what I want you to do, and you don't have to have Mr. Gaddy right next to you during your event, but your hearing for next week. But what I want you to do is talk to him about your available option, because what's very clear to me is that you're not listening to the questions that are being posed to the court. Right? I say, are we having a hearing or are you accepting responsibility? I need an answer to that before we can go forward. You making a statement isn't evidence. That's not evidence, Mr. Lewis. And because you want to represent yourself, you're going to be held to the same standard as if you were a defense attorney appearing in front of this court.
It's refreshing to see that this judge has just identified this man as being a sovereign citizen, because that's exactly what it is. And it is rather evident that he is out of his league. He better get an attorney.
You can change your mind about that and have Mr. Gaddy represent you.
No, I don't want any.
But in the meantime, I'd like for you to talk to him in the next week so that you guys can discuss what the proper way is to go about dealing with the court. Because as of right now, you're not following the proper criminal procedure. You don't get to just make statements. There's an order to things. So you can find that out for Mr. Gaddy. This case is adjourned until next week. We'll see you back on the 6th. Or exactly, Ms. Armstrong, does that give you enough time, or do you need to put it up 2 weeks?
Be released.
Oh, sorry, Mr. Attorney General, does that give you enough time to do a writ, or do you need more time than that?
Judge, our office will request 2 weeks, just to ensure we have time.
We'll put it up 2 weeks.
Am I being remanded to jail, ma'am, or am I free to be released and come back in? Because I came in on my own accords, ma'am. I have no problem with coming back. Whatever day.
I'd like to make a bond motion, I'll hear that.
Yes, I would.
First, I'll put the recommendation from probation on the record.
Thank you.
The recommendation is for Mr. Lewis to serve 4 days in jail with 4 days credit. And to report to Agent Priest, to report to probation on March 2nd in the office. Your Honor, I'd also like to make note that I have a note here that indicates. Your Honor, may we approach?
Yeah. I'm sorry, ladies and gentlemen, for those of you, we need to have a private conversation because we have Mr. Attorney General is not here in person. We have to clear the courtroom. That prosecutors. Okay, Mr. Taft Lewis, got additional information. You know, if you wanted to see me, there's a different way to do that. If you have a motion, or part of that is by working with an attorney who knows how to navigate the procedures of the court. Again, your choice not to use an attorney. I still have the standby counsel for the public defender should you choose to avail yourself of their decades of legal knowledge that might help you navigate this process.
Ma'am, I thought this was the hearing. I didn't know it.
Pardon?
I thought this was the hearing because last week I could not speak also because he said it was your case and I would be able to have my turn to speak when I was in front of you. Now I'm in front of you and you're telling me this isn't the hearing also. So I didn't know how you guys were going to proceed. I just want to be heard on what information I have. Like I said before, I asked for this warrant so that I could get in front of you so that I could say this information to see which way.
And Mr. Taft Lewis, that's exactly what I'm saying, is that you would use the assistance of the public defender's office or your attorney who assisted you at the time of your case. You wouldn't have had to violate your probation to get in front of this court.
Wow, so this fool purposely violated his probation just so he can get a court date. This literally doesn't make any sense. and he has no idea what he's doing, and he's clearly only going to make things worse for himself.
I don't believe that you are a flight risk. I think you just made poor decisions. So I am going to release you, but you are to respond here in person, which is March 6th.
No problem.
On Monday at 1:30, and that is the date and time set for your hearing.
Yes, ma'am.
At that time, I would expect you to follow the proper procedure that any other criminal defense attorney would be held to the same standard. You still have the public defender at your disposal if you choose to consult with them.
No problem.
Could you also order him to report in person, probation office on?
You'll have to report to probation tomorrow. I'm sorry, March 2nd.
Yes.
You'll report to probation on March 2nd to meet with your agent.
Which agent is that? Is that Agent Moses, Agent Miller, or Agent Priest?
Agent Priest.
No problem.
Your Honor, if I could ask Mr. Lewis to contact my office and give us the, address and phone number.
Did you hear that, Mr. Lewis? The public
Yes, I
defender is availing themselves to you.
I have no comment on that, but yes, I did hear him, ma'am.
I'm releasing you on PR.
Much appreciated, ma'am.
Okay, we
Is
will
that on
see you
all-
back
is
here.
that on all warrants? I had 3 warrants, one from the court fees and fines, I had one from FOC, and one from the violation of probation. Is that all warrants? I'll be released on PR?
Yes, and yes.
Much appreciated, ma'am. I will see you March 6th at 9
See you
a.m.
then. It's 1:30 p.m.
On
1:30.
March 6th.
You there? at
March
1:30?
6th.
Yes, March 6th.
Okay. All right.
Number 33, People versus Hillary Marshall, 22321 FH.
In this man's mind, this was a win for him, but he is clearly too ignorant to realize that he is still going to wind up back in jail because he wants to represent himself, and he has no idea on how to actually do that.